I'd like to welcome everybody to Temple Sinai. This is being sponsored by the Sisterhood. My name is Roseanne Rose. I'm one of the presidents, along with Carol Carmine, who wasn't able to make it this morning, excuse me. I'm pushing the day. This morning, our presenter is Scott Solkoff, who's a Florida Bar Board Certified Specialist in Elder Law. He founded the firm Solkoff Legal, PA. Scott and his late dad, Jerome Ira Solkoff, are co-authors of the leading textbooks on the subject. The firm represents the elderly people with disabilities and their caregivers, as well as regular trusts, wills, etc. He has written numerous articles and has been a keynote speaker at numerous seminars on disabilities and elder law. He graduated from the University of Florida, and his law degree is from Nova Southeastern University. Please welcome Scott Solkoff.
Thank you very much for that introduction. And hello, everybody. Hi, and hello, everybody online that will see me later. So, today's a big topic, and what I thought I would do, and I want to thank Hannah for putting this together, having the idea. And I was asked to talk about estate planning and getting affairs in order and dealing with long-term care issues, but also to talk about what it would be upon the death of a spouse, what that means to an estate plan and what it means to moving on in the right way. Of course, that's something I deal with very, very commonly for 30 years. So that's something that I will address as well. And then some other new issues that have come up in the law, and more so than new statutes or new changes, more so in customs that lawyers have learned to use to help people, that I will update you on so that you can think about it yourself. Because this is a relatively manageable group, and because you guys on screen can't ask me questions, we can make it a more interactive talk today, which is a lot more exciting than just listening to Scott Solkoff drone on. So I'm a lawyer, which means I can talk forever without interruption. My mom reminds me of that sometimes, and so your job is to stop me. Just if you would raise your hand. If I feel like I'm in the middle of a thought, I'll tell you, hold on, and then I'll come back to you. And Eric has a microphone, so he's going to do like a Donahue, where he'll be able to go down the aisle and give you the microphone to be. Everybody remember Donahue? Yeah, okay, good. And then you can ask any questions that you have. So I am a board certified specialist in elder law. 2% of the attorneys in the state of Florida are board certified by the Florida Bar as a specialist in any particular practice area. What board certification means, and you should know this when you're looking at hiring a lawyer, is that that lawyer has gone through an additional vetting process by the Florida Bar, which is managed by the Supreme Court of Florida. And that is additional testing, like another bar exam, but in your practice area. So you got to know the stuff. It's got a very low pass rate. And then they do an audit of your practice to make sure that you have enough experience in cases in that. You have to be practicing for at least 5 years in that practice area. A certain percentage of your practice must be in that area. And then they ask all the judges and lawyers what they think of you. And so you have to have a decent reputation. So I'm honored to be board certified in the area of elder law. And it's a bit of a misnomer. Some people say, oh, you're an elder law attorney, you don't look that old. But it has nothing to do with my age. It has to do with the specialty. And even that's a misnomer, because people of all ages come to elder law attorneys because either they're older or they want to be older. Or they know somebody who's older. And that means planning ahead and making sure that you've got a good system in place to make sure that everything is in order. The difference between elder law and estate planning is that elder law attorneys do estate planning. We do wills and trusts and how to handle your estate after death. But the focus is different. The focus is on the lifetime needs of our clients, as opposed to what happens after death, which is the traditional estate planning model. We do estate planning, got to know that, we got to be specialists in it. But we're also focusing on lifetime needs. What are some lifetime needs? What do you think, from a legal perspective, an attorney might focus on when dealing with clients for issues that take place during lifetime? Yes. Making sure you have enough money until you die. That's important. Now, we can't come up with new money out of our pockets, so we have to look at other sources of money, right? And oftentimes that's making sure that our clients are making full use of any government benefits that can be gotten. And most people don't know about all the government benefits that can be gotten. So yes, an elder law attorney does that too. Anything else that you can think of? Yes. Medical needs, health, that's exactly right. So elder law attorneys focus on healthcare. Very big part of our practice, particularly when it comes to long-term care. What do I mean? Home health, assisted living, dementia care, skilled nursing homes. Do you have any idea how much a nursing home costs in our neck of the woods of Southeast Florida right now? How much?
10,000 a month.
10,000 a month is the average in the state of Florida. More here in Palm Beach County. My clients are generally in facilities, if they need a nursing home, that is between $12,000 to $16,000 a month for a shared room for one person. When I first started practicing in 1995, wow, the average cost of a nursing home at that point was $4,500 a month. That outpaces inflation. It means that long-term care has gone up higher than even other costs. So it's expensive, and most people cannot afford that care, didn't know how to plan for it, don't have insurance for it. So elder law attorneys help make that safe and secure and okay. And that gives great peace of mind to people to know that that's taken care of. What else? What is another lifetime need? Yes. Pardon? Fraud. So we term that in our parlance as abuse, neglect, or exploitation. And this could be exploitation by a person, a caregiver, I hate to say it, but sometimes even a child. It can be even a spouse. Very rare, but it can happen. More commonly, it's, believe it or not, corporations that are taking advantage of people. And we've been involved in some very big cases, national class action lawsuits against some of the biggest companies for specifically targeting the elderly. Elder law attorneys get involved in that as well. Anything else that would be a lifetime need? Yes.
A special needs child and well,
Thank you. That's a very important thing. This is the answer was anybody that has a special needs child. How do you make sure that that child is also taken care of? And therein lies another difference in wording and verbiage. We're called elder law attorneys, but really we're helping people of all different ages. And that would be a person with disabilities that also may be reliant on need-based government benefits, could lose those benefits if they receive an inheritance. That could be very problematic. And elder law attorneys, because we're involved in that field and that area in the community, we also would know about resources in the community and different programs that might help that person, that child with disabilities, or the person that comes to us with a disability. So that's another thing. One big issue that we see, one of the hardest things that I see is would be parents coming to me and say, Billy's been disabled all his life. We've been taking care of him. We know everything that he needs. We know he doesn't like bananas. We know he doesn't like, all the little things that make a difference. How do we make sure Billy's gonna be okay when we're gone? That's a tough issue. So we deal with that too. All of those things. So let's move on a little bit. Thank you for those, that input. Yes? So the question was, what about your will? Well, that's not a lifetime need, and you should know this. Here's a very interesting feature about wills. They only help you after you die. Right? A will says who gets what when you die. And a will, therefore, only helps you after you die. It's important. I want you to have your wishes honored, but it doesn't help you while you're alive. So that's an example of where, in my world of elder law, I would be looking at first what you need to be living as high a quality of life as possible with all the things that we just talked about and more. And then we tie that into your wills or trusts or other devices that take care of what happens after death. Yes, one more, and then we'll move on.
There was just one other thing. I've heard stories that people are put out of their homes. People are put out of their homes because they don't know what the status of their home is. In other words, it could be in a husband's name, a partner's name, and then, I mean, there were all kinds of repercussions. I know of someone who all of a sudden was left out of her home and had to leave her home because she didn't own it. She just lived in it with her partner.
Okay.
So,
Good. I'm going to address that in a bit in more detail, but just to make it clear, especially for those that are listening online, the point was, what about the home? What if I survive my spouse or partner or whom I'm living with? How do I have a roof over my head? The question was, I know people that have been forced out of their homes. So yes, another thing that an elder law attorney, because we deal with it all the time, is going to think about, right? If we see that, if we see a person living in a home that they do not have title to and therefore not have the legal right to remain in the home possibly, we've got to think about that too. So these are excellent examples of where traditional estate planning does not address the real needs of people. And this is where the evolution of legal planning has gone. And I think it's fair to say that estate planning attorneys who were trained only in what happens after death, or primarily in what happens after death, are becoming more and more educated in these lifetime needs issues because of the burgeoning field of elder law. And there's more and more and more of a coming together. And I think that in the law, certain times we develop standards of practice where if you don't think about these things as a lawyer, you're not living up to your obligation, right? And this is becoming standard of practice, a lot of these things. I'm going to bring up one other point that wasn't brought out, at least specifically, and that is incapacity planning. Most of my clients that I see over time, if they don't come to me where there's already some cognitive impairment, we plan as if there will be. Because as you know, it's very, very common. And so what if I have a client who's capable and fine up here, got all their marbles? I, as the lawyer, even though it's not pleasant to think about, I'm thinking about what should happen if my client is no longer capable of making their own wishes known, or making decisions and signing the documents and understanding what they're doing. I want to make sure that they're not taken advantage of. I want to make sure that their wishes are honored. I want to make sure that they're protected so that they get what they need during their lifetime. That's another very big part, maybe the largest focus in elder law, because it deals with healthcare. It deals with all the things that you just brought up, right? So I have some notes for myself, so I remember to tell you everything that you need to know today in 1 hour. How about that? So one of the things that I alluded to was long-term care. Believe it or not, even though we worry about the stock market, and everything goes like this with the stock market, right? When it goes like this in the stock market and you're in your 40s, you can deal with it, right? You can deal with changes. You can deal with being caught at a downturn because you probably are going to make it to an upturn, and it'll even out. And in the American economy and in recent years, it keeps on going up, even though there's dips and valleys and and mountains. But actually, the biggest threat to your finances is not the stock market. What is it? It's the cost of long-term care. That is what wipes most people out financially. So planning for that becomes really, really important. Most people spend a lifetime trying to be careful to save money. We all do better jobs or some worse jobs than others, right? And you may look back and say, well, I shouldn't have bought that. But the bottom line is all that work and thought that you put into that and all the work that it took to accumulate those assets is all for naught if it's all gone, and then you become impoverished or have less money than you thought you would to live on for the rest of your life, or let alone to leave anything to the kids. So planning for long-term care costs, the point that was brought up already, is very important. And that is something that elder law attorneys focus greatly on because of that threat. In fact, I would say it is the reason why lawyers like my father, Jerome Ira Solkoff, one of the founders of the field of elder law, started to look at the issues of public benefits. How do we pay for long-term? What if I need a home health aide on a long-term basis? How am I going to pay for it? There's only 3 pots of money possible to pay for that. There's Scott Solkoff's money, whatever I've saved, and whatever income I have coming in. There's long-term care insurance, which most people have none of. And even those that do usually don't have enough, or it gets denied. One of the largest consumer insurance products for denials of service. So one is my own pot of money. Second pot would be long-term care insurance if I have any. And third pot of money, the only other pot of money, would be need-based public benefits. Somebody shouted out, I'm going to say this for the benefit of you on the screen, Medicare. No, Medicare, right. Medicare doesn't cover any long-term care. And I'm glad that you brought it up, because most people, when I say, how are you going to cover the cost of that home health aid, will say, I have Medicare, or I have a supplement too that I pay for. No, Medicare or your supplement will not cover long-term care. It covers fix-me-up care, makes me healthier. If I get sick, I go to the doctor, I go to the hospital. The closest Medicare and or a supplement and or a Medicare HMO come to paying for long-term care is a rehabilitation benefit of up to 100 days. That is it. Okay. After that, I am on my own, and I have to pay that $10,000 a month or $12,000 or $15,000 a month, unless I have long-term care insurance. And so then we look at Medicaid as opposed to Medicare. Medicaid is a long-term care program from the government, federal government. And there are federal and state rules that govern the accessibility of Medicaid, how we apply, what we need to do to get it. And the bottom line is this: Medicaid is financially need-based. So they want me to be broke before I can get Medicaid. So I remember my father telling me, and others that were in the field very early, that people would come and say, I've got X number of dollars left. Maybe I got $300,000 left, $500,000 left, whatever it is. Now today, I might have a client that says I have $1 million left. That used to be a lot of money, okay? But now if I'm looking at $170,000 a year of long-term care costs, and that's just the long-term care, let alone all of my other expenses, and for my spouse or partner to live, and for me to give money to the rest of my life or to my children, that's often not enough. So my father and his colleagues, when they founded the field, they were looking at how can we help these people? How can we find another pot of money? And the answer was Medicaid. How can we make it so that the government rules can be used to protect assets? So that we can legally make it so that even though we have money, the government's not allowed to count it. And this took a lot of doing. This took a lot of looking at the rules and laws and figuring out what the government was allowed to count as opposed to what they could count. And figuring out ways through those rules and laws to help people so that we could show the government everything that we did, but still be able to qualify for these benefits. Now, let's say I have 3 children, all good, honest, trustworthy, thrifty, wise, prudent, all good kids. And I have, just for illustration's sake, let's say I have $600,000 and I got 3 kids and I know I'm needing help and I want to qualify for Medicaid. What do most people do? They give away their money. They give it to the kids, right? And by the way, contrary to most opinion, the kids usually do the right thing, right? Sometimes not, but usually do. What does the government say if I give all my money away and then apply for Medicaid? It's too easy. They say no. They say, don't come crying to us. You just gave all your money away. So what they do is they say, we're going to look back. And this is where you might hear about Medicaid look back periods. The government says, I'm going to look back 5 years to see if you made any gifts. And if you did make gifts 5 years prior to your application for Medicaid, we're going to disqualify you for Medicaid for a period of time. And that period of time is calculated based on a formula that the government uses to figure out how many months or years of ineligibility there will be. So from my perspective, when I'm sitting down with a client, if I have a client that's healthy and fine, trusts their kids, they have good kids, and I ask a lot of questions, we may be able to come up with a gifting strategy that understands this 5-year look back period and how best to use it for our clients. And there, we don't give the money directly to the kids. We create a special kind of a trust, right? It's a special kind of a trust just done for this purpose. I'm going to explain trusts in a moment, so put a tack in that. But think of it as an artificial entity that I'm giving my money to. And now the kids don't own it themselves, but they can control the purse strings. And ultimately, now that money's not mine. And the government can't count it as mine as soon as I put it into that trust. There still is a look back period that I have to deal with, but if it's a part of my plan, I can think that through and develop an overall strategy for how I'm going to finance my long-term care if and when I need it, even if I need care during that 5-year period. So one way elder law attorneys help their clients is to use gifting strategies that make sense. There's another way, another category of plan. And that is, it might not surprise you to know, human nature, that sometimes, often, maybe more often, people come to the elder law attorney and say, I need care now. My spouse is in the rehab and I don't think they're going to be able to come home, and it's going to cost $14,000 a month, and I'm scared and I don't have enough, and what's going to happen? We don't have 5 years to wait. So there are other strategies that elder law attorneys have developed and used regularly that allow us to get around the 5-year look back period altogether. Pros and cons to all of these planning strategies, but it allows us to make sure that we can, if we need it, get the help that we need without waiting 5 years. So that can be a very big deal. Now, questions. This is a good time to answer questions. Yes.
So, if, like, I'll just use me as an example. My money is in a trust. All my money is in a trust. Sorry, all my money is in a trust. My home is in a trust.
But you're talking about another trust?
Uh-huh.
Okay, so can you?
So the
explain it a
question
little?
was, if you didn't hear it, was all my money's in a trust. But you're talking about another trust? Yeah, I am. Okay, the type of trust that most people create, and that's a good segue into what is a trust. The type of trust that most people create is called a revocable living trust. Maybe you have one, or you certainly know somebody that has one because they're very popular, particularly here in Florida. A revocable living trust, think of it as an artificial legal entity, kind of like a corporation. Okay, so I'm speaking to you today from Temple Sinai. Temple Sinai is a corporation, a special kind of corporation, but it's a corporation. It's an artificial person in the law. It can it can file tax returns. It can have bank accounts. It can own things like this building. That's an artificial entity. Same thing with a trust. If I have the Scott Solkoff revocable trust, my trust can own my bank accounts. My trust can own my brokerage account. My trust can own my home. My trust could be the beneficiary of my life insurance or my retirement accounts. My trust becomes the vehicle that can pass my assets on to my heirs instead of a will. And that's because the trust has two parts to it. A while I'm alive part, which says basically, while I'm alive, the money can only be used for me, Scott Solkoff. And I'm the trustee, which means I hold my own purse strings. So I create the trust. I'm the beneficiary of the trust, and I hold the purse strings because I'm the trustee. I run it. So there's really no difference in the way I do my banking, pay my bills. Nothing really changes. But the big benefit is this. If I become incapacitated, I'm alive, I'm not dead, but I need help. My successor or co-trustees step up and they take over seamlessly. There's no court procedure. It's relatively simple. And then they use the money only for me while I'm alive. Then, after I die, those same or other trustees hand out the money according to my wishes. With a will, it would take a probate proceeding to do that. They have to go to court, hire a lawyer, spend a lot of money, delay, a lot of headache. A trust avoids all of that. So that's why you see so many revocable living trusts. But here's the issue with a revocable living trust. Because I am the beneficiary and I run it, the government looks at it and says, well, you're the same person. In fact, they use a term called a pass-through entity. It's the same. So they look at me and my trust as the same person. In fact, I file my tax returns under my name. It doesn't matter to the government because we're the same person. But if I give up control, if I'm not the beneficiary in the same way, the government can't count it as mine. And there are certain types of irrevocable trusts that I give up control over, that we therefore use in a Medicaid planning context. Does that make sense? Okay. Now, if I give up control, that's a big downside, right? A lot of people don't want to give up control. But sometimes this is the best decision a person can make. If the kids are honest, trustworthy, thrifty, wise, and prudent, I might name my kids as the trustees. And if I don't have children, or I don't have children who are the capable in that way, I can appoint anybody else. I get to pick, right? So that's something that some people choose to do, is use a special kind of trust done to qualify for Medicaid and give away the money after they die, right? It's something we discuss with our clients, but it's not used all the time. It's not for everybody. There's another way of doing planning, and that is I can, ahead of time, while I'm okay, set up a system through various documents where I'm not giving up control of anything, but that on the eve before I need to apply for Medicaid, because I did all the work ahead of time, my family or whomever I appoint can pull the lever and take the next steps to allow me to qualify without a waiting period. All different ways that lawyers help. How do we figure out the best way for our client? Listening, talking. This is where a lawyer, a good lawyer, is going to listen and ask the right questions. Knowing which questions to ask is where that makes the difference between lawyers, frankly. Knowing which questions to ask, listening and drafting the documents so that they accomplish all of these goals that are specific to that client. And that is why your friend's plan is not your plan. There may be similar components, but they're not your plan. So yes, question.
I have two questions. One is about veterans, aid and attendance, and that kind of long-term care. And whether it makes sense if someone is a veteran, would be eligible if they needed it, but is not yet connected to the VA system. Does it make sense to get enrolled ahead of time, way before you might need it?
Let me take that question first, if I might, if you could hold on the second question, unless it's closely related. Okay, so I don't embarrass you. There's a gentleman sitting in the front row with a hat for the 101st Airborne, right? And I had the privilege of asking, what did you do? Do you mind I was a gunner in a helicopter, he said, right? Wow, okay. I mentioned my generation was the first in a long time that didn't have to go to war. We didn't have a draft. And I guess I'm fortunate because of that, but also grateful for your service. When you serve the country during time of war, Congress and the American people have decided that that is worthy of special benefits. And Congress has said, mandated, that if you did serve the country during war, even one day during wartime, that you are entitled to a special benefit later on called enhanced pension, commonly referred to as aid and attendance. And what this program does is makes it so that we have a separate pot of money for wartime veterans and, listen, their widows or widowers. So because you married the right guy or gal, it's possible to get benefits because of your spouse's service during wartime. How many people, veterans or widows or widowers, do you think even have any idea that this benefit exists? Very few. And if you go to the VA website, va.gov, which happens to be a surprisingly good website, there's thousands of programs. And this is not featured front and center. People don't know about it. And yet it can be very useful. So the question is well taken, and that is, can that money be used to fund long-term care? And the answer is yes. In fact, there's an enhancement, why it's called enhanced pension, to be able to qualify, especially if you have long-term care expenses that are therefore reducing your usable income because it's not reimbursed somewhere else. And the VA gets this, and they give you money. But you can't qualify for it unless two things exist. One, you know about it. And second, you qualify, and it also is based on financial need. Elder law attorneys know how to do that, right? So that a part of your plan, if you're thinking about it, would be, I want to make sure I give away my stuff according to my wishes. And that's why most people come to a lawyer, and how do I give away my stuff after I die? Right? They don't even know that the lawyer can help with all of these things during lifetime. So the lawyer may ask you a lot of questions. Why is the lawyer asking me if I want to plan for my incapacity? Why? Well, because that's more important. It's more important that you have what you need while you're alive, or there is nothing left after you die, and you don't have what you need. So looking at benefits like Medicaid and these VA benefits can be really, really, really important. Second question. Did that answer your question?
Partly. So for someone to qualify for these VA benefits, then they would need to be enrolled with the VA, or is that a completely separate?
The question is, do you need to be enrolled in the VA to get this benefit? Only when you apply, okay? And then you can be enrolled in the VA. You don't have to enroll ahead of time. And that's something that we coordinate for our clients, because there's a timing issue in terms of when we apply, how long it's going to take, how to get the VA moving, because you may have heard the VA is very busy And there's, our magic tricks to make that happen. Yes.
Okay. The other is about powers of attorney. Is it too soon to ask that question?
No, not too soon.
Okay.
In fact, I would say it's never too soon to ask about powers of attorney. Why? Because
Okay.
they're the most important legal document you can have. And yes, I'm going to talk about it in much greater detail.
Okay, but the question really is the durable power of attorney created in New York years ago, will that still be valid here in Florida now?
Will my power of attorney created in New York still be valid in Florida now? Let me expand that question. Will my legal documents created in another state be valid in Florida when I need them? The short answer is yes. And if I stop there, you'd think, okay, no problem. Well, the United States Constitution has a clause you may have heard of, the full faith and credit clause of the US Constitution. The full faith and credit clause means simply this. Every state, remember, the whole point of the Constitution was we were confederating. We were bringing all these states together as a union. They had to figure out what to do. And they realized that if somebody did legal documents in one state, that they'd have to make it so that every other state honored every other state's contracts. And that's exactly what it is. So it means that a power of attorney or other legal document created in another state that was valid in that state under that state's laws when it was created is valid in every other state as a general rule. However, we have as many bodies of law as we have states and territories. That has been the case since the beginning. And so it means that Florida's legislature might say, here's what a power of attorney is. And another state may say, no. Here's what a power of attorney is. And different rules about how they're signed, different rules about what you can do with that power of attorney, what rights you can give to a person, or a will, or a trust, or any other legal document. And so for some documents, the differences are significant enough that even though they are legally valid, they're not good enough. And a power of attorney is one of those. Power of attorney law is very state-based, as opposed to a revocable trust, which is much more uniform. Many times we don't need to make big changes or any changes to revocable trusts. They're very similar. That's because they're based on what we call the common law, not statutory. Powers of attorney are statutory. And so in my view, my advice is always, if you're going to be in a new state, but you did your documents in another state, do new documents, particularly powers of attorney and new healthcare documents, which are very state-based. I'm going to explain more about powers of attorney in a bit. Yes.
Question about, I was told something that might not be true, but I was told that sometimes an attorney can take the amount of care that you need for the rest of your lifetime and deduct that from your actual income. I know that sounds too good to be true, but in other words,
It's too good to be true.
yeah, in other words, if I'm gonna live, say, 5 more years, and I need a certain amount of care that I can prove that I need, is that deductible from the income that bases everything on your income? And,
So
am I clear? Am I being
to
clear?
rephrase,
Yeah,
if I've heard that an attorney can look at my anticipated long-term care costs and deduct them from my income. And I would say the answer to that is no. If I were to, there are some ties in that I might be able to draw parallels to, but if I said yes, it would be very misleading. The bottom line is the answer is a solid no. You cannot look ahead and say, I think I'm going to need this care, and therefore I'm going to deduct it from my income. What I would say is when I have a client and we're applying for VA benefits in particular, or sometimes Medicaid benefits, income and what I'm spending that money on does become relevant. But I can't look ahead and get some deduction. No. Okay, so let me get back to powers of attorney, because I said it's the most important, and I want to make sure that we don't leave here today without focusing and addressing. Why do you think I say it's the most important? There's directions for what you want to happen. And really what that power of attorney is a document that I sign that says, if I can no longer do for myself, I elect you to do for me. That's a powerful document. It means, generally speaking, if I can sign, you can sign. In the right hands, therefore, a power of attorney is a very good, powerful document that allows me to pick my agent who can move forward with my wishes, make sure that things get done, who pays my bills if I can't do myself, make sure that my bank accounts are set up right, even creating estate planning changes that may benefit me because of changes in the law or changes in my circumstances, could even move forward if the power of attorney allows for it with asset protection devices like we've been talking about. Powers of attorney are not boilerplate documents, at least they shouldn't be. People think they are. If people think it's a form, it is not. The power of attorney that we use typically is a document that we created tied in with our planning. So for example, let's say I appoint my children as my agents. And I say, I want you to be able to make decisions for me. If I can't do it, I want you to be able to do it. And they move forward and they've got the ability and they're good, honest, trustworthy kids and they sign things for me. The law says in Florida that a power of attorney agent, my children, are not allowed to do anything that transacts with themselves, which makes sense to me. Makes sense to you too. I see all the head nods. Why? Because it will be a conflict of interest. If I appoint somebody to do something and then they can transfer money to themselves or do something like that, that could be bad. So Florida law says, no, you can't do that. But if I sit down with my client and I talk to them about all the reasons why it may be helpful to do that, for example, moving assets around to protect them, my clients might say, yeah, you know what? They're good kids. If I feel comfortable enough to appoint them in all these other ways, I feel comfortable with that. So we put special language that bypasses that for prohibition. And we're going to create other very specific provisions that must be in that power of attorney that aren't in a general durable power of attorney that allow the agent to be able to do more so that we can accomplish all these things. If that language is not in there, they cannot do it. So the power of attorney, I'll just finish with this and then take some questions. The power of attorney, I think, is the most important document for everybody. And that's because while I'm capable, I can do my own thing. I make my decisions. I don't need anybody else to step in. But I don't know when that rock is going to fall on my head. I want to make sure that I've got the right people that I pick who can step in and take over and do what I need them to do. And this power of attorney's got all the instructions and all the rights and powers and authority legally enforceable so that anybody else has to honor it. And in fact, now under Florida law, if the document was signed in Florida under the new law, any third parties, banks, anybody must honor it. And if they don't, there are penalties for doing so. Powerful document. What's the negative? In the wrong hands, this is nothing more than a license to steal. It gives somebody the right to go to my bank accounts and take out money. If they were bad people, they could run off to Tahiti with my money. So now they'd go to jail if they came back, right? It's illegal, but they could. And so I need to be careful. And this is why in your discussion with your lawyer, you talk about these things. Is there a way to control this? How can I make this most effective and most safe, while also making sure that my children do not have unnecessary liability, that they can't be sued for doing things under this power of attorney? Questions? Yes. Can the agent under the power of attorney be in another state And the answer is generally yes.
I'm a widow and I have a checking account by myself. Do you suggest having one of my children's names on it, or is it not necessary?
I'm a widow and I have a bank account in my name alone. Might it be a good idea for me to put one or more of my children on these accounts? Yes and no. How's that for a lawyer's answer? The answer is that with a power of attorney, a good, thorough, durable power of attorney with all these provisions, it allows your child to access that account without being an owner. And so in so doing, I can make it so that my child can pay my bills, do everything they need to do without being an owner. What's the advantage of that? Well, if they're an owner and they get into a car accident, they get divorced, anything bad happens, that's their money too, because they're an owner on that account. And so as lawyers, we're looking at all what's the safest way to make this work? And typically it would be using the power of attorney. That said, if we're using an operating account where the income's going in and going out, we're not putting a lot of money in there, I'm okay with it. But it's something that we talk about with our clients. Sure. Yes, sir.
Let's suppose we hire an attorney, we work with him for years and years. He dies before we die. Secondly, what happens if our kids who are in the will dies before us? How does that get transferred over to others?
The question is, what if my lawyer dies before me? And it could happen. And I have to think about that too. Well, the answer is well-drafted documents are drafted to be able to be enforceable and read and understood if the person dies, the client or the lawyer. And so a new lawyer would be able to look at a well-drafted document and understand exactly what's happening. I do it all the time. I have to look at other lawyers' documents. And so it's something that should happen automatically as part of the drafting process.
Now, what about if you will money to your children and they die before you?
What happens if you will money to your children and they die before you? Your properly drafted legal documents will take that into consideration before they die. It'll say, if my children die before me, here's what happens.
Okay.
I think it's malpractice if they don't. Because again, we have to think about what should happen if our client is no longer able to make changes to those documents, or if the lawyer's not there. We want to make those documents as if they're the last documents that will ever be done, even though they may not be, so that we're thinking about that. Yes.
It's my understanding that in Florida, that when you sign a durable power of attorney, it becomes effective immediately, not when your incapacity starts.
Oh, you're good. So the point was, I understand in Florida that the power of attorney is immediately valid, not just when you become incapacitated. But Scott, you just said that you can do what you need to do, and it only needs to be done when you're incapacitated. Yes, I did. So here's the thing. Under Florida law, you are absolutely right that the power of attorney is legally valid and enforceable and immediately valid upon signing. Whereas in some other states, we can say this power of attorney is not powerful, it bestows no rights until I'm incapacitated. In Florida, that's not the case. Interestingly, when I started practicing law, it was not the case. You could not do what were called springing powers of attorney that spring into existence when I'm incapacitated. Couldn't do that when I started. But then because we thought, I don't need power of attorney to be valid now. I only need it when I'm incapacitated. Lawyers went to the legislature and we said, we support a new law that would allow springing powers of attorney. And they passed it. And we now had springing powers of attorney. We tried it for about 2 years and said, oh, this isn't working. And we went back to no springing. Why? What were the problems? Because I have to prove that the person's incapacitated. And that's easier said than done. And meanwhile, nothing's getting done for that person. Nobody has the right to act. And frankly, if I trust that person enough where I'm going to appoint them to act for me when I can't watch what they're doing, I'll appoint them now. And so generally speaking, it makes sense to do, and it is the law in Florida in any event. But I meant what I said. They don't need to do anything before I lose my marbles. And if they do, I can cancel at any time if they do something that's wrong. Yes, sir.
Just maybe a follow-on to that, I didn't understand that's what those power of attorneys work. Does it take time? Let's say something happens to you, or maybe even something doesn't happen to you, and your agent in the power of attorney is gonna act. Do they just walk into a bank with with the power of attorney signed, hand it to the teller and say, give me the money? Or is there, the banks require more than that in order to honor that power of attorney?
The question is, am I hearing, Scott, that the power of attorney is valid immediately and the agent can just walk into the bank and say, give me money? The answer is yes. It is that easy. What's the process? I show my ID to prove that I'm the person named in the document, the agent, or also known as the attorney in fact, and the bank has to honor it. And if they don't, they have to state reasons. There's a whole body of law now on enforcement of these documents and penalties if they don't. So, and most of the time that becomes very important because I want my agent to have the right to do what needs to be done without third parties, banks and financial institutions slowing down the process. Sometimes out of a desire to protect their depositor, but often for reasons to protect their own behinds. And so the law changed to force these third parties to accept them immediately. Yes. Will that carry through to another state?
Power of attorneys in Pennsylvania, will those laws still be okay?
So the agent can be in any state.
Okay.
And Florida law defines the rights, but just like I said before, if the bank is in Florida, they're gonna know that law and they're gonna be bound by that law. The
But
banks in
in
Pennsylvania,
too.
if the assets are in another state, that financial institution might not understand, probably won't understand the enforceability of this document. They emit different rules and laws that they're used to, and it may be more difficult. And so sometimes when we're meeting with a client and we're going through assets where the agents are, we might say, let's do our documents in Florida. Let's also do this document for Pennsylvania or Alaska or
Okay.
wherever. Yes.
Okay.
So if I understand you correctly, an irrevocable trust, you can't change any. Is that true?
With an irrevocable trust, I understand you cannot change anything. Is that true? And the answer is not really. The law now allows, relatively new laws, now allow people to change irrevocable trusts under certain circumstances when it's consistent with the overall purpose of the trust. And sometimes it requires either the consent of everybody involved or a judge can order and authorize changes. But generally speaking, the whole point of an irrevocable trust is I am giving up some control.
Okay, so, but this is, can you change the trustee without going to everybody or?
So the question is, can I change the trustee without going to everybody? And the answer is if the trust allows it. And this is again where the attorney has got to think and say, would it make sense for this client to retain the right by provisions in the trust to change the trustee, or maybe even change the beneficiaries in the document? And depending on the purpose and use, intended purpose and use of that trust, it may be, yes, we can retain those rights.
So it's not total. In other words, you can write it so it can be tailor-made to you if circumstances change.
So it's not a total irrevocable trust. That's correct.
Okay.
It can be tailored to the specific needs of that client.
And
It should be.
the second thing is, how often should you have a trust reviewed?
So how often should you have a trust? And I'll expand that to your other legal documents reviewed. And I would say it's a good idea to at least call the lawyer every 2 years or so and say, what's going on? Now I can tell you that in my practice, and we're very organized and we've got our systems in place. We will send out notices if there's a big to-do, right? That requires people to consider their changes. But it's important for you to be taking control of your own planning. And yes, talking to your lawyer every couple of years
Okay,
for
thank
that
you.
law firm. Yes,
Power of attorney.
I have a power of attorney for my friend, which I'm going to read in depth, really, because I haven't really read it in depth. But everything goes to her one child. Do you just give the power of attorney, show the bank who the survivors are that get the bulk of what's left, or
so
how
good
does?
question. The question was, and then I'm gonna move on to another topic because I see we're running out of time. I want to make sure that we cover everything. The question was, can the power of attorney go to the bank and then hand out everything after my death? The answer is no, emphatically no. Powers of attorney expire upon death. They are no good. The power of attorney is a lifetime document only. What governs the use of my or distribution of my assets upon my death would be a will, which requires probate, or a trust agreement, which allows immediate access to the accounts by the trustees, which is why often the trustees are the same people as the powers of attorney, wearing different hats with different power.
Can you reiterate the trustee? I'm sorry, I missed that.
So the difference between a trustee and a power of attorney, and it's a question that plagues banks and brokers, and it's what's the difference here? Is powers of attorney expire upon death, trustees don't. That's one difference of many, but that's to answer that question. Okay, next. I've been asked specifically to talk, and I'll come back to other questions, but I want to make sure that we get through our time, our hour with this. Special considerations for widows, widowers, and if you're not a widower, you might be, or if you're with a partner, not married, and that might happen. How do you deal with those issues? Well, first of all, part of it is learning new things. This isn't the lawyer thing. I'm a human being too, in addition to being a lawyer. And I understand that part of the issues that my clients face, meeting with thousands of people over 30 years, I will hear things such as, I never dealt with the money before. I don't even know the passwords to the accounts. I don't know how to keep a checkbook. This was my partner's, my spouse's responsibility. I didn't do that. So to that I answer, you need to learn it, and you will learn it, and it's not as hard as you think, and you're perfectly capable of doing that activity, right? And your lawyer can guide you or refer you to people that can help make that happen. There's a team approach sometimes to this with an accountant, a financial advisor, and your lawyer, and maybe the children to make things work. But yes, that's a transition that we need to be mindful of and that needs to take place. And this ties right into the continuity of information. If I'm in charge of the money, I need to convey to the right people what's going on in case I do die. Now, today, it's not my birthday, but today I'm 58 years old. I hope to be 59 next year, this year, but I don't know. So I wrote what I call a death book. This death book is, hey, guys, if I die or I become incapacitated, here's where you find everything. Here's where my passwords are kept. Here's how you access everything. Here's what I've been doing. Here are the assets. Here are the accounts. Here's the name of my doctors. Here's the name of my lawyer, and so forth. Right? Important to do. Continuity of information. And if you're not the one in charge of these things, but your spouse or partner is, talk to them, blame it on me, say, I heard Scott Solkoff say this, and get that conversation done. Very important to have that. Even if you don't have that information, are there ways to get it? Yes, but it can be a pain in the neck. It can delay things. It can cost money. So the best way to do that is to communicate properly. If you don't, if you have concerns about giving this information to certain people, you can use your lawyer. Tell the lawyer those things. Let the lawyer be able to convey that information at the right time to the right people. That's another option. But better if you trust them is to give that to them directly. And that ties into choosing the right people. Many people say, well, I have these kids, so this is who I'm going to appoint. Well, that's not necessarily the case. I think there's somebody using a tambourine, which is great. It adds a little bit of flavor to my speech. But it's not necessarily the case that you have to appoint your children. Maybe your children aren't the best people. You know, in fact, maybe it could lead to conflict in the family. Family dynamics are really important. And then I have to decide, do I want to appoint people to serve together? Or do I want to appoint somebody, maybe one child's going to do this job and another child's going to do this job, and it makes it more clear for them about what they're doing so that there's no arguments. Or maybe I'm going to say, I appoint this person, and then if that person can't do it, then this person, I'm going to have a laddered succession. This is an important part of your conversation with your lawyer, right? The lawyer will know to ask you these things. Good lawyer will know to ask you these things. And if they don't, you have to bring it up. You have to say what you want. And here, let me tell you about my kids. That's important. If a spouse partner dies, one of the questions would be, what happens to me living in my house? What do I do? Am I going to get kicked out of my house? The answer is, if you're not on the title, if you are not on the deed, if you are not an owner of the property, you could get kicked out of the house. And so that's a part of your planning that needs to be had. For example, what if I am living with my longtime partner? I don't have a home. I moved into his house. I want to make sure that I'm okay. My partner wants to make sure I'm okay. That needs to be done legally. It can't be, I'm going to tell everybody to let you stay there. No, bad. I've seen so many problems. So this needs to be a part of a plan. It needs to be talked about ahead of time. And there are certainly ways to deal with that. Even if you're married, there are certain rights when you're married that don't apply if you're not, where you're allowed to stay in the home. But that's not necessarily a given. And so you should talk to the lawyer about this. The lawyer will know to ask these questions, or should know to ask these questions, but it's something to put on your list. And then another issue, should I get married or not? Should I remarry or not? You fall in love, you find somebody good, that's great. Should you get married is a legal question as well as it is a religious or romantic one. And talk to your lawyer to find out the pros and cons of marriage. There are both. There are advantages of marriage, and there are also disadvantages to marriage. Whether marriage is going to be legally on the plus side of your balance column depends on your circumstances. So you want to talk about this over your estate planning conversation with your lawyer. Easy last comment on death of a spouse would be, if your spouse dies before you, what happens with Social Security? Some of you know this. You get the larger of the two. That's exactly right. So you should know that. That applies to, it's a survivorship benefit, right? Okay. I think we covered a lot of ground. I would like to be able to take any of the questions that you have now and see if I can help you even more.
Okay, you said you were going to say the legal documents that we should have beside a will and power of attorney. What else is needed?
Good. So the question is, what other legal documents do I need? Remember, I said at the beginning, and I meant it, what your neighbor has is not necessarily what you have. So this is going to vary from person to person, but I'm going to give you the general package. The general package that works for most people would be a will and or a trust and or a will, trust agreement and or a will. Remember, both of these documents can be what happens after I die documents. The trust can also be what happens while I'm alive document. So a trust and or a will, your lawyer will discuss this with you. a power of attorney, number one, most important. Healthcare advance directives, which include, all this means is healthcare directions that I need, or that I make in advance of needing them. So what's the number one healthcare advance directive? A living will. You've heard about this, a living will. A healthcare surrogate designation is another advanced healthcare directive or healthcare advance directive that allows me to pick the person who's going to enforce my living will. The living will says what I want or don't want if I'm very sick and I can't communicate with the doctors. And hold on to your seats, folks. Here, I can do springing. I can say only if I'm incapacitated does this person have the right to step in, okay? So my healthcare surrogate, called a healthcare proxy in some other states, enforces my wishes. We also do another healthcare advance directive called a healthcare power of attorney. Scott, why do I need a healthcare power of attorney if I already did a healthcare surrogate designation? And the answer is what I told you before. I want you to think back using lawyer head. I told you before that Florida law has very strong enforcement provisions for powers of attorney, requiring all third parties to honor them or face penalties. Not so with healthcare surrogate designations, different. So I want to do both. I want to appoint my agent to be my healthcare surrogate and my healthcare power of attorney so that we have a sword as well as a shield. Yes. Yes, totally different document. So these are separate statutes that we're using to define rights and responsibilities. They can be put into one document, which is what we do, because we want a doctor or a hospital and the agents to be able to read this document and understand that there are three parts to it: a living will, a healthcare surrogate designation, and a healthcare power of attorney, and what those differences are and how they work together. So you should know that. Yes.
Well, yeah,
Going back to Medicaid, is there a certain amount of money that you have to have in order to collect Medicaid?
The question was, going back to Medicaid, is there a certain amount that you have to have in order to be able to collect it? And the answer is yes. Medicaid is based on financial need. And what I meant before by saying protecting assets is taking countable assets and making them non-countable, making it so that even though I have $1 million or whatever it is, by the rules and laws of the government, they're not allowed to count it because the lawyers set everything up so that these assets, even though they're there, are not countable against me. And that we've used the rules in the way that's most advantageous to me and my family. Yes, I'm sorry. Yeah, oh, yes.
so you mentioned two different powers of attorney and also trusts. And these documents conflict with each other in terms of the people you have as your agent. One different person in the trust, somebody else in the power of attorney. And what happens in those situations?
So the question was, if I name one person to be my agent under the power of attorney and another person as a trustee, can there be conflict? Yes, because one person is holding the purse strings to one entity, the trust. Another person is dealing with finances and contracts and legal issues regarding my own personal stuff, and there can be conflict. And so it would be rare to do that. And the lawyer, if you're going to do that, is going to have to take special precautions to make sure that everything works out.
So you have the same lawyer draft book documents, so there isn't a conflict. It shouldn't conflict with each other.
Almost always, the same lawyer would be creating those documents together for you. I don't know anybody that has created a trust agreement that then goes to another lawyer to do the power of attorney. Your lawyer, because your lawyer is going to think about this. Your lawyer's going to say.
Do it or amend the power of attorney or amend the trust later and it changes.
That's fine. So the question is, well, I may need to make changes, but the lawyer that's meeting you to do the power of attorney will require you to show him the other legal documents because it's absolutely essential. The lawyer cannot create new documents that may conflict with your current documents. And the only way he or she would know that is by reading your other documents, which means it does take the lawyer more time, by the way. It's interesting. It takes a lawyer more time and effort to help a client that comes with documents already prepared because the lawyer has got to read those documents, but that's the way it is. Yeah.
Partner dies. and a partner dies, and they rewrite a trust in their name. Say they didn't have a combined trust, say they had two different trusts, the husband and wife, and now the husband's gone and the wife rewrites her trust. Then the trust from the husband is like null and void, am I correct?
So the question was, if you're married and your spouse created a trust and you created a trust, separate trusts, and now the new spouse makes changes or modifies the existing trust for the survivor, isn't it true that now everything has changed? Everything can be changed. Is that summing it up?
Yeah,
Okay, so the answer is that can be a very big danger, actually. Also an opportunity. I mean, you want to make sure that there's flexibility for both spouses. But at the same point, think about this for a moment. Let's say that we both agree, maybe it's a second or further marriage. And let's say we both agree that half of everything will go to my kids and half of everything will go to your kids. And then the survivor comes into control of everything and then changes the whole estate plan, everything goes to their kids. That could be a problem that goes against the wishes of the decedent spouse and the wishes that they both agreed to beforehand.
well,
So a good lawyer is going to talk to you about that danger and say, is there a way that we can make this so that it works where the survivor spouse still has some flexibility, but can't change the whole estate plan? So that's one part of that. The other part of that is sometimes it makes sense to be able to make changes, and we need to leave room for that as well. It's a complicated issue, and that's why trusts and wills and estate planning is not always as simple as it may seem. Yes.
well, what if it's written pretty much the same, but just in the one person? In other words, if the surviving spouse just rewrites it to make it current because she's or he has received all of the assets, whatever it is, and it's the same wording, but it's just in one name, then the first trust is null and void. Is that correct?
So the question is what if the new spouse, the surviving spouse has the trust, but the same wording is there? In other words,
Yeah,
in my example, all the same beneficiaries,
right.
everything,
right.
nothing's changed there. Is it still, does that work? And the answer is that it depends where the assets are. Now, remember that I said that the trust itself is an artificial legal entity. So let's say I have a trust, Scott Solkoff has a trust, and Scott Solkoff's spouse has a trust. My trust owns my assets, let's say, and my spouse's assets are owned by the trust. And this varies greatly. Usually both spouses' assets can be owned by one trust. But let's say I have them separated out. If my assets are still owned by my trust, the survivor does not have the right to be able to make changes necessarily, usually, to my trust agreement that owns my assets, and my assets don't necessarily travel to the other trust agreement. This depends on the language of the documents. It can, but it doesn't necessarily mean that it will. So this is a very specific question that's going to vary depending upon the wording of that document. How do we know how to word it? The lawyer has got to talk to you and listen.
Okay, supposing it is exactly the same, all of the assets that were combined are now in one person, but all of the other parts of the trust, as was the beneficiaries and everything else, is exactly the same.
The question was, again, what happens if everything's the same and all the assets travel over to the new trust? Yes, there's nothing else that changes, but the assets don't automatically travel over to the new trust.
No, but they don't automatically, but over a period of time, they are all brought into the new trust because of the way.
Well, so the question is, over a period of time, the assets could be brought over to the new trust. No, not necessarily. If this decedent spouse's trust says that those assets go into the survivor's trust, then yes. But not always is that the case. Sometimes it is.
Okay.
And sometimes we might say some of the assets go and some of them don't. And there's all different ways of protecting the client's wishes that need to be taken into consideration. Thank you for the question. Yes, sir.
I'm married. Suppose both of us die at the same time. What happens to all these documents?
We're married and both of us die at the same time. What's an interesting issue that we spend weeks on in law school, the simultaneous death issue. What happens? Your estate planning documents will literally say that. If we both die at the same time, here's what happens. So it's your wishes that control, and the lawyer's gonna put it into the documents. Yeah, what a great group, yes.
So you said the documents that we should have in our possession is a will, a power of attorney, and a health power. of
Thanks for
attorney.
bringing me back to that.
Okay, is there anything else?
The will or trust, power of attorney, healthcare advance directives, and what else haven't I mentioned? The home. How do you deal with the home?
Yeah.
And this is going to depend on the client, but here are the two biggest ways of doing it. Number one would be making sure that the home is titled in the name of a trust agreement. If I'm using a trust agreement, the trust can own the home. Properly drafted, the trust retains all of the protections of homestead. And we have many great creditor protection benefits and tax benefits that can accrue to the owner of the home. Those can pass into the trust agreement, properly drafted. And so that's one way. A second way is through a device. Have you ever heard of a ladybird deed? This is a neat device. The ladybird deed says, I own the home for the rest of my life, or me and my spouse own the home, or me and my partner own the home for the rest of our lives. But immediately upon the last of us to die, it goes to so-and-so. It's like a beneficiary designation, right? There's much more to the ladybird deed, which, by the way, was named and invented by my father, Jerome Solkoff, and is now used all over as a tool. So it is absolutely necessary for your lawyer to consider how your home should be titled as part of your estate plan. And it might be to the trust, it might be to the ladybird deed, it's either or, not both. And it might be that you trust that your deed is left exactly the same, but your lawyer will address that with you. And sometimes give you choices based on what works for you. Yes.
I had a neighbor when we were younger. We lived in a house a townhouse that had 3 floors, and everybody had 3 floors. So she was an elderly lady in a second marriage. Her husband died, and she had a lifetime estate in the house, but it had 3 floors, and she would have liked to have been able to sell the house and move to something with only 1 floor. She couldn't do it because she had a lifetime estate, and his kids would get the house if she moved.
Yeah.
And
Hey.
she had no other way of paying for the new house.
So this is an interesting issue that most people wouldn't even think about, right? But it becomes a problem, and it became a problem for your friend. And this is the problem, to restate it, is my friend received an interest in the home that allowed her to stay in the home for the rest of her life. But immediately upon her death or the sale of the property, or if she moved out, it would pass to the children of the decedent, of the person that died before. This is a common way of protecting a spouse, to make sure that, say, my wishes, I want my home because I paid for it, I owned it, I want it to go to my children, that's the right thing to do, but I wanted to make sure that my spouse or partner has a roof over his or her head, and they're going to be able to stay. So a common way to do that is by giving what we call a life estate or a life use in the property so that they can stay there. The question was, yeah, but what happens if that person needs new accommodations because they can no longer, for example, go up the stairs and they need a new place, but if they move out, they got nothing. So that's a very good question to discuss with your lawyer. And the lawyer can actually draft accommodations into that estate plan that say, if the person moves out, the home can be sold, a new home can be purchased, but must name the children as the beneficiaries, is another way of accomplishing that. And there are even some other more customizable tools, but it's a conversation that has to be had with the lawyer. And it's up to the lawyer to know to ask those questions.
example, if you set up a trust fund in which your child is only allowed to take a certain amount of money out per month or per year, he goes to the lawyer and he says, I need more money than this. Can he or she do that?
Oh, good, okay. So this is a good question. Perhaps we can end on, maybe I'll take a couple more questions, but the question was, I may create a trust agreement that names my children as beneficiaries, but maybe I don't want them to receive it all at once. Maybe I want one or all or more of the children to receive it over time. This may be beneficial in a number of circumstances. But what if that child needs more money than the allotted amount? Can the trustee give that to them? It's a drafting issue. The lawyer can either say, and this is the way I teach other lawyers, we have mandatory distributions and discretionary distributions. A mandatory distribution is every month you must give $2,000 or X number of dollars to that person. That would be mandatory. Trustee has no discretion, got to do it. But their discretion is limited. They can't do anything other than that. But I might also say, I want my trustee to mandatorily give $2,000 a month, but have the discretion to be able to use the money for other things. I can list those things and be very specific and say, for example, if my trustee deems it in the best interest of that child, they could use the money for healthcare, education, or the general welfare of that individual, to maintain their style of life. I could do all different kinds of trusts are infinitely flexible almost. And they allow for drafting. And so a good conversation with a lawyer is going to be, tell me about the kids. And that brings up all kinds of things with my clients. Well, Billy's not working right. Why isn't he working? I want to know. Maybe he's disabled and the client didn't think to tell me that because they didn't think it was important. Or what about the fact that the spouse of that child can't be trusted, even though the child can be trusted? What about the fact that the child's too irresponsible with money? All these things go into how we draft that trust agreement. It's one of the beauties of trust agreements. It allows us that kind of flexibility. Does that answer the question? Okay, what a terrific group. Thank you for allowing me to address you today. Thank you for asking all the great questions that you did. I appreciate it very much, and an honor to talk for the Sisterhood of Temple Sinai. Thank you very much.
Thank you very much, Scott. And I'd be remiss to say, Doreen, thank you, Scott's mom. Thank you very much for being such an integral part of the temple and bringing your son to us. Thank you very much.